Legal and Privacy Brief for March 19, 2026. Federal courts allow Cadence Bank's $5.25 million MOV-IT breach settlement to proceed, while Massachusetts dismisses a separate Wiretap Act claim against healthcare providers for pixel tracking. Spain's DPA fines BBVA euros 100,000 for debiting accounts without consent, and Russia-linked hackers deploy sophisticated iPhone exploits targeting Ukrainian sites. The Supreme Court hears election timing arguments that could affect mail-in ballot deadlines in 15 states. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief March 19, 2026. Next section, Litigation Updates. $5.25 Cadence Bank data breach class action settlement, case No. 1-23MD3000 and 83AD D. Mass. Cadence Bank agreed to pay $5.25 million to settle claims it failed to protect customers from a May 2023 MOV-IT breach. Class members can claim up to $2,500 for ordinary losses, bank fees, 4 hours of lost time at $25/hour, or up to $10,000 for extraordinary losses, unreimbursed fraud, credit repair fees. Those without documented losses receive $100 plus 2 years of credit monitoring. The settlement covers individuals notified their personal information was compromised between May 28-31, 2023. Claims must be filed by June 4, 2026, with final approval scheduled for July 9, 2026. Compliance action. Financial institutions using third-party file transfer software should review vendor security controls, verify breach notification procedures, and document incident response capabilities. Update cybersecurity insurance coverage to address supply chain vendor breaches. Sources: top class actions. Marquee Software Bank vendor breach exposes 672,075 customers' bank software. Vendor Marquee Software confirmed that an August 2024 breach exposed names, addresses, social security numbers, dates of birth, and financial account information of 672,075 individuals across at least 74 financial institutions. The breach occurred on August 14, 2024, affecting the company's customer relationship management platform used by banks to track accounts and marketing touchpoints. Community First Credit Union disclosed that Marquee Software paid a ransom to the attackers, though no ransomware gang claimed public credit. Multiple financial institutions sent breach notifications, but several affected banks were not included in the official list of 74 institutions. Compliance action. Banks using CRM vendors should audit data minimization practices, limit sensitive data shared with third-party platforms, and verify vendor breach notification timelines. Review vendor contracts for indemnification clauses covering third-party breaches. Sources: The Record. Eggland's Best must face class action over cage-free eggs, case No. 1-24 CV 6222 ND. Ill, U.S. District Judge Franklin Valderrama ruled on February 27 that plaintiffs sufficiently alleged Eggland's Best misled consumers by claiming hens are free to roam in a pleasant, natural environment when they are confined to industrial facilities without outdoor access. The court rejected Eggland's Best's argument that the statement is puffery, finding it makes a verifiable promise about hen living conditions. Plaintiffs claim they paid a premium for cage-free eggs based on this representation. The court dismissed injunctive relief claims without prejudice, finding plaintiffs failed to show intent to purchase the products again. The case moves forward on damages claims. Sources: top class actions. Blue Buffalo class action sparks insurance coverage dispute, case No. 3-26 CV 328 D. Con. Nationwide Agribusiness Insurance filed a declaratory judgment action seeking to determine which insurers must cover defense costs for an underlying class action alleging Blue Buffalo dog food caused heart problems in pets. The underlying case, Walsh v. Blue Buffalo, case No. 1-25 CV 5808 N. D. Ill, claims Blue Buffalo failed to disclose ingredients linked to dilated cardiomyopathy. Nationwide claims it is defending Blue Buffalo under a reservation of rights for policies issued between 2016 to 2018, but argues some alleged injuries occurred outside coverage periods. The insurer seeks proportional cost sharing from Hartford and Blue Buffalo. Sources: top class actions. Massachusetts court dismisses Wiretap Act claims against healthcare providers. Progen v. UMass Memel Healthcare, 2026 WL 632770 D. Mass. A Massachusetts federal court dismissed Wiretap Act claims against healthcare entities for embedding pixel tracking technologies that allegedly transmitted protected health information to third parties. The court applied the heightened intent requirement for the crime-tort exception, holding that plaintiffs failed to plead defendants purposefully committed HIPAA violations. The court explained that merely alleging defendants knowingly installed tracking tools or disclosed information is insufficient. Plaintiffs must show defendants purposefully committed the criminal or tortious act itself, not that violations were side effects. Compliance action. Healthcare providers using website analytics should document privacy impact assessments showing intentional compliance efforts. Implement technical controls limiting PHI transmission to third-party analytics platforms and maintain written policies prohibiting intentional HIPAA violations. Sources: Inside Class Actions. Jehovah's Witnesses abuse DMCA subpoenas to unmask critics. The Electronic Frontier Foundation is defending an anonymous Jehovah's Witness member operating JWS Library, a research website that archives and analyzes the organization's historical documents. Watchtower Bible and Tract Society sent DMCA subpoenas to Google and Cloudflare seeking to unmask the website operator, despite having no history of filing infringement lawsuits. EFF research shows Watchtower filed 72 copyright subpoenas since 2017, but never used the information to file lawsuits. Instead, the organization initiates disfellowship proceedings to ostracize critics. The JWS library content qualifies as transformative fair use for research and commentary purposes. Sources: TechDirt. Next section, Enforcement Actions. Spain's DPA fines BBVA euros 100,000 for unauthorized account debits. EPT exp 202,408,496. Spain's Data Protection Authority fined BBVA euros 100,000, reduced to euros 80,000 after voluntary payment, for processing personal data without a legal basis under Article 6(1) GDPR. The bank redirected a SEPA direct debit mandate from a closed account to a new account without authorization. The DPA held that SEPA mandates are linked to specific IBAN, and the bank needed new authorization to debit a different account. The DPA rejected BBVA claims of implied consent, finding consent must be freely given, specific, informed, and unambiguous through clear affirmative action. The DPA also rejected alternative legal bases under Article 6(1)(b) contract performance and Article 6(1)(f) legitimate interest, finding the bank failed to conduct required balancing tests. Compliance action. Financial institutions must obtain explicit authorization before applying payment mandates to new accounts. Document consent with clear affirmative actions, not silence or absence of objection. Conduct and retain balancing tests before relying on legitimate interest as a legal basis. Sources: GDP Rub exp 202,408,496. Next section, Regulatory Guidance. Supreme Court hears election mail-in ballot timing case. Watson v. Republican National Committee. The Supreme Court is hearing arguments on whether federal law requires mail-in ballots to be received by Election Day or only postmarked by that date. The case challenges Mississippi's 2020 law allowing ballots postmarked by Election Day to be counted if received within 5 business days. The Fifth Circuit ruled federal law requires all ballots to be received by Election Day, reversing a district court decision. Mississippi argues that election refers to when voters cast ballots, not when officials receive them, citing the court's 2020 ruling in Republican National Committee v. Democratic National Committee. A ruling requiring Election Day receipt could append laws in more than a dozen states allowing post-election ballot arrival. Sources: Scadu S. blog. Federal court issues preliminary injunction against HHS vaccine schedule changes. U.S. District Judge Brian Murphy in Boston issued a preliminary injunction blocking HHS Secretary Robert F. Kennedy Jr.'s changes to CDC vaccine schedules and staying the appointment of 13 ACIP committee members. The court ruled Kennedy violated the Administrative Procedures Act by replacing the entire ACIP committee without following required procedures. The DOJ argued Kennedy's actions were unreviewable, claiming he could advise the public to get measles instead of preventing it without judicial review. The court rejected this position. ACIP had issued controversial recommendations, including advising against universal hepatitis B vaccination for newborns. The government plans to appeal. Compliance action. Healthcare organizations should continue following pre-2025 CDC immunization schedules pending appeal resolution. Document clinical decision-making based on established medical standards rather than suspended ACIP guidance. Sources: TechDirt. Netherlands court upholds compulsory education exemption data processing, RB. Noord-Holland HAA 25/1285. A Dutch court held that municipalities lawfully process lists of objections to schools when reviewing compulsory education exemption requests under the Leerplichtwet 1969. The court rejected an Article 17 GDPR erasure request, finding the municipality must maintain detailed school-by-school objection lists to investigate exemption claims. The court held processing was necessary under Article 6. 1. Because the compulsory education officers and courts must verify objections to all schools within a reasonable area. The Archival Act requires municipalities to retain exemption decisions. The court found processing proportional because the goal of verifying exemption claims cannot be achieved with less privacy-intrusive methods. Sources: GDP Rube. Next section, Privacy Developments. Russia-linked hackers deploy dark sword iPhone exploit against Ukrainian's Russia-linked threat actor, UNC 6353, deployed dark sword malware targeting Ukrainian users through watering hole attacks on compromised news sites and court websites. The malware exploits iPhone vulnerabilities patched by Apple in late 2025, allowing attackers to gain deep device access with minimal user interaction. Dark sword operates on a hit-and-run model, rapidly extracting emails, messages, photos, credentials, and cryptocurrency wallet data within minutes before self-deleting. The campaign targeted Coinbase, Binance, Kraken, MetaMask, and Ledger users. Lookout researchers noted the malware is professionally designed with modular architecture, suggesting access to commercial surveillance tools. Google reported Dark Sword was also deployed in Saudi Arabia, Turkey, and Malaysia by various threat actors. Compliance action: organizations should enforce mobile device management policies requiring iOS updates within 30 days of release, block access from jailbroken devices, and implement certificate pinning to detect interception attempts. Sources: The Record. University of Mississippi Medical Center recovers from 9-day ransomware attack. Restored all clinics on March 2 following a ransomware attack detected February 19 that paralyzed the Epic electronic medical records system. The attack forced closure of most outpatient clinics statewide and cancellation of elective surgeries. Staff used manual downtime procedures with pen and paper for 9 days. Confirmed communication with the attackers, but has not disclosed their identity, ransom demands, or whether payment was made. The FBI, DHS, and CISA, the Cybersecurity and Infrastructure Security Agency, are assisting the investigation. Is still determining whether patient data was compromised. The medical center is operating extended hours to address the appointment backlog. No statement confirmed data exfiltration. Compliance action: healthcare entities should test downtime procedures quarterly with timed drills. Verify Epic offline access capabilities and train staff on paper-based order processing. Review cyber insurance policies for business interruption coverage and notification cost reimbursement. Sources: top class actions. Meta's AI glasses raise privacy concerns. Meta's new AI-enabled glasses are creating privacy concerns, as wearers can capture photos and videos without clear indication to bystanders. A new Android app has been developed to detect smart glasses nearby, allowing individuals to identify when they may be recorded. The technology raises questions about consent and reasonable expectations of privacy in public spaces as camera-equipped wearables become more ubiquitous and harder to distinguish from regular eyewear. Compliance action: organizations should update workplace policies addressing wearable cameras in facilities handling sensitive information. Post signage prohibiting recording devices in areas subject to attorney-client privilege, HIPAA, or trade secret protections. Sources: Schneier on security. Next section, policy changes. CISA official reports no uptick in cyber threats amid Iran conflict. CISA acting director Nick Anderson stated the agency has not observed increased cyber threat activity from Iran since U.S. and Israeli strikes began in late February. CISA continues working with Stryker following a March 11 cyber attack by Iran-linked Hendala Group. Anderson raised concerns about AI-accelerated attacks creating a velocity problem for vulnerability disclosure, suggesting the current 1-2-week CVE, or common vulnerabilities and exposures, publication timeline may be inadequate. CISA is studying whether to shorten required response windows for critical vulnerabilities. Sources: The Record. DHS nominee Mullen declines to commit on CISA staffing restoration. Senator Markwayne Mullen, nominated as DHS Secretary, declined to commit to restoring CISA budget or rehiring personnel cut by Secretary Noem. Under Noem, CISA lost 1/3 of its workforce and hundreds of millions in budget cuts. Mullen stated he would recruit the right people without specifying staffing levels. Senators warned that conflict with Iran will likely trigger cyber attacks requiring full CISA capabilities. The Michigan striker attack by Iranian actors was cited as evidence of escalating threats. CISA previous acting director Gadu Makala was moved to a new role amid multiple controversies, with Congress calling for an investigation. Compliance action. Critical infrastructure operators should not rely solely on CISA coordination during the agency's reduced capacity period. Establish direct information sharing relationships with sector ISAC and peer organizations. Review incident response plans to ensure self-sufficiency. Sources: The Record. Intelligence community omits election threats from Annual Assessment Director of National Intelligence Tulsi Gabbard defended excluding foreign election interference from the 2026 Annual Threat Assessment for the first time since 2017. Senator Mark Warner questioned whether foreign threats to midterm elections no longer exist. Previous assessments documented Iranian, Russian, and Chinese influence operations targeting elections. Warner stated, the intelligence community is no longer being allowed to speak honestly about it. Gabbard disclosed she observed the FBI's January raid on Georgia election records at the request of the president, but did not participate in law enforcement activity. Senator Jon Ossoff questioned her presence given no evidence of foreign involvement in that investigation. Sources: The Record. Next section, Compliance Takeaways. MOV-IT Settlements Proceeding. Organizations affected by the May 2023 MOV-IT breach should verify they have notified all impacted individuals and filed required state breach notifications. Review vendor contracts for indemnification clauses and coordinate with legal counsel if class actions are filed. Deadline for Cadence Bank settlement claims is June 4, 2026. Wiretap Act heightened intent standard. Healthcare providers using website analytics must document that tracking pixel implementations were not intended to violate HIPAA. Conduct privacy, impact assessments before deploying third-party analytics, and maintain written policies prohibiting intentional disclosure of PHI to marketing platforms. GDPR consent for payment redirects. Banks operating in EU jurisdictions must obtain explicit authorization before applying SEPA mandates to new accounts. Silence or absence of objection does not constitute valid consent under Article 6(1). Document all consent with clear affirmative actions and conduct balancing tests before relying on legitimate interest. Mobile device security amid nation-state exploits. Enforce 30-day patch windows for iOS devices accessing organizational data. The Dark Sword campaign demonstrates sophisticated actors are deploying zero-day exploits against recently patched vulnerabilities. Block jailbroken devices and consider MDM solutions with jailbreak detection. Reduced CISA capacity planning. Do not assume federal coordination will be available at historical levels. Critical infrastructure operators should establish direct peer-to-peer threat intelligence sharing and verify incident response plans can execute without CISA support. The 1/3 workforce reduction at CISA means longer response times for voluntary assistance requests. That concludes today's legal and privacy brief. From Carolina Clear Tech. For informational purposes only, not legal advice.